All right, so Breaking Bad is the story of Walter White, a struggling high school chemistry teacher who turns to a life of crime, learns to love it, and achieves immense success previously unknown to him. Trial lawyer Jack Sharman, who's with the Lightfoot Franklin and White firm in Birmingham, has had his share of clients with the Walter White syndrome. Those clients have brought Jack corporate internal investigations, kickback cases, grand jury investigations, gaming matters, criminal environmental offenses, public corruption enforcement cases, FCPA matters, congressional investigations, election contests, Medicare fraud, key TAM lawsuits, and investigations by military officials. And Jack tweets. Jack is the publisher of the firm's Twitter feed about white-collar crime, which you can see at White Collar Wire. Please welcome Jack Sharman.
All right. So you're an internal lawyer or risk manager. And this coming Tuesday, you're back in your office, you're looking at your computer, you're looking at your LinkedIn homepage, because although you had a great time in Laguna Beach, you really want a different job. And while you're looking at your LinkedIn page, you're interrupted by a phone call. It's a panicked colleague who says that one of your company's facilities has had a federal search warrant executed on it. So you get in the car, go to the airport, get in another car, get picked up, go out to the facility, and start interviewing witnesses and employees to try to find out what happened. Your next employee interview walks into the little conference room where you are and says, "I'm on the side of the FBI. Whose side are you on?" At that point, you really do want a different job. I'm Jack. We have Gerry, Jackie, and Joel, and we're going to spend a few minutes this morning talking about white-collar crime issues as they affect business lawyers and civil litigators. At the end of the day, of course, nobody considers himself, herself, or their company to be a criminal, although sometimes we think we know such people. They're not us. I encourage people to ask questions. I'm going to be the timekeeper, but don't hesitate to interrupt. And I'm not going to spend time on these folks' qualifications. They're all extremely qualified and good-looking, and so I encourage you to pay attention. And we're going to start off with Gerry, who's going to talk a little bit, among other things, about your case, your business case, and public perceptions of that. Gerry?
Thanks, Jack. Good morning, everybody. I'm going to steal a page out of Nicole's book, our next panelist, who talks about and frames her issue around location, location, location. Well, I want to talk to you about communications, communications, communications. And I'll tell you why I'm focused on that. As a lawyer, and we're all lawyers, I view myself, and I think we all need to view ourselves, as advisors, as counselors. And especially in the year 2013, I think we need to view ourselves as crisis and risk managers. It's all about the reputation, and as my partner, Scott O'Connell, who's going to do a panel a little later, would talk about, it's about brand, right? It's all about the brand and reputation of your client's company, their business, their organization. Now, in the materials, Jack cites the 3 cases that I've either personally handled or managed that were high-profile media cases. Now, in Boston, we recently tried the Whitey Bulger case. And if you're not Boston-centric or you didn't happen to follow that, if you saw Leonardo DiCaprio, Jack Nicholson, and Matt Damon in The Departed, it gives you a snapshot of what the Bulger case was, because the movie was written about the Bulger case. The other case that Jack cited to which I prosecuted was the shoe bomber case, Richard Reed, which happened 100 days after September 11th. And the geopolitical issues swirling around that one made it obvious that that would be a high-profile media case. For those a little older, like me, when I tried the Louise Woodward case back in 1997, 1998, All you had to know was that President Bill Clinton and the UK Prime Minister Tony Blair were going back and forth over the merits of the case on a fairly regular basis. So there's a snapshot of the type of cases that I've been fortunate to handle in the past. But that's not what I want to talk to you about today. I'm happy on the sidebar to talk to you about how interesting those cases were. I want to draw a broader picture for you, and it's this. We have to, as advisors, counselors, as crisis and risk managers for our clients, we have to pay attention to social media, the media, and public communications. Because it is all about the reputation, it's about the brand of our clients, and frankly, the public communication can be so significant that the damage is done way before the litigation even starts. So, I'm from a family of football coaches. You'll hear me draw analogies and references which sound like sports analogies, but you've got to anticipate in this business, and that's based on experience. You've got to prepare. You've got to have a plan, otherwise there's no way you're going to be able to execute. And if you can't do that, you're going to be looking back at a very negative starting point, because as we all know, this is a real competitive business, and any advantage is key to you. Right? We always said, I was an elected district attorney before I came to Nixon Peabody, and we always talked about defining ourselves. Right? You've got to define the client before somebody else defines them. Right? A good manager is one who can put out fires. The great managers are the ones who make sure the fires never happen. And in the criminal defense business, explanation before the accusation is optimal. These are the type of things that you should have in mind on what I call the front end. Okay? It's when the client comes to you. Maybe even before the client comes to you and you've read about the matter. If you're reading about the matter, you're reading about your client, you're reading about your client's stakeholders in the newspaper, that's something you must pay particular attention to, and pay particular attention to on the front end. Now, when I say client, I draw a pretty wide spectrum because there's a lot of stakeholders when we talk about our clients. There's a lot of people who are interested. If a board of directors is relevant, then the board of directors is in the mix. If shareholders are relevant, then they're in the mix. Whether it's the client organization, the shareholders, the board of directors, other interested persons, they all need to be in the mix when you're forming your plan, when you're preparing, when you're anticipating. Especially as it relates to the adversary or the opponent being the government. Now, I just spent 20 years in government service. I was elected district attorney in the largest county in Massachusetts. I was the first assistant U.S. attorney and terrorism coordinator at the U.S. Attorney's Office, and I was the criminal bureau chief at the AG's office. So I spent 20 years in that space. And I can tell you, whether I was the elected or appointed, or I worked for the elected or the appointed, public communications matter to them. And they matter to everybody who's under them. So don't think that if that case and your position is getting leverage publicly, that isn't helpful to you. You're crazy. It is. It's very helpful to gain leverage through public communications, whether you do it affirmatively or whether you do it well responsively. And it has to be on the front end. You don't want to be looking back at a bad public communication, one that you can't repair, that does harm to the reputation of the client. And lastly, impact. We talk about reputation, we talk about the matter or the case, and that reputation and brand can be damaged long before the litigation starts. Well, there's a continuum. Again, it starts with anticipation and preparation with all of the stakeholders, including the client, obviously. It continues on a continuum during the course of the time that you're representing that client. And during that time, you've got to continue to form a plan, alter a plan, which continues to allow the public communications to help you in your positioning and your leverage as you attempt to resolve and win whatever dispute it is. And that can be before charging, it can be during the pendency of the case, or it can be at resolution time, hopefully when you haven't been charged and convicted. The last thing I'll say about this, and I think it's very important, and Jack asked me to mention it, but there are ethics attached to this. The rules in Massachusetts, both state and federal, reflect each other. There are rules about public communications, extrajudicial statements that are made, especially during the course of litigation. So I'm never an advocate for doing anything that would cut against those rules, But oftentimes, as I saw in the Bulger case, you'll see a seesaw effect, which is one side does one thing and the other side does the other. Well, in the Massachusetts rules, it does allow defense counsel to respond when they or their client haven't started the seesaw, but they need to tip it back the other way. Thanks, Jack.
All right, great, thank you. A lot of times, of course, the problem is not only criminal, it's not only civil, it can also be criminal, civil, administrative, regulatory, and of course these are called parallel proceedings, and Joel's going to chat with us a moment about those.
When Jack forwarded me the title of this presentation, the name Walter White didn't come to mind, but rather his attorney, Saul Goodman. Now, I can see some of you out there are smirking, and for those of you who are, that really doesn't require any further explanation. But for those of you who don't have any idea what I'm talking about, Saul Goodman is the attorney for Walter White and his partner, the high school chemistry teacher turned crystal meth drug lord in the Southwest in the show Breaking Bad. The reason I mention him is because over the course of the show, Saul Goodman redefines, at least for me, the term parallel proceedings, because in representing Mr. White, he has to deal with state and federal investigations, potential civil liability, IRS audits, not to mention his own clients and the Mexican drug cartel occasionally trying to kill him. It's a situation, granted it's television, and I'm sure that most of us in this room will never face the ethical, moral, and legal dilemmas that Mr. Goodman does in his practice, at least on the television show. And by comparison, most of our practices likely border on the mundane. But that doesn't mean that everyone in this room, whether we're outside counsel or in-house counsel, are immune from the types of issues that arise often and frequently in parallel proceedings. And that type of situation occurs whether or not you're representing a doctor in a civil litigation individually, and there are issues related to False Claims Act or anti-kickback statutes, or whether you're representing the owner of the Cleveland Browns, Jimmy Haslam, in connection with very complicated civil class action proceedings with a massive federal fraud investigation on top of that. Now, we could talk all day about a lot of the different issues that relate to this topic, but I want to focus really on one thing today, and that's disclosures to the government and how that impacts and what the interplay is there between that and civil litigation. On the first point, you heard Jack talk a little bit earlier today about the fact that most people in this room, most of our colleagues, our coworkers, and the companies that we work for don't view themselves or their companies as criminal. And there's a good reason for that, because most of us and most of the people we work for and the companies we work for are good people who aren't criminals, who try and do the right thing. But that doesn't mean that those companies and the individuals are immune from government scrutiny. Now, as either in-house counsel or outside counsel, when you receive that subpoena from the FBI or the letter from an attorney general's office saying, I want to see every record you have on such and such a topic, and I want to have interviews with all of your employees on that topic, and I want to do it 2 weeks from now. When you get that request, either as in-house or outside counsel, you're going to have to take that up to your boss, be it the CEO, the CFO, the general counsel, or the business folks that you deal with. Chances are those people haven't been involved in that type of situation before, either ever or infrequently. So when they do, they're going to have a lot of questions for you, and their natural reaction is going to be, I'm not a criminal, I don't associate with criminals, I think everyone on my team are good people. Why is the government coming after me? Why are they asking these questions? What can I do to make this go away? How soon can you make it go away? And why hasn't it gone away yet? Those are the types of questions that we face and that we have to deal with, and properly assessing and dealing with this type of situation requires putting on a slightly different hat than just coming at it from the perspective of a purely civil litigator or a criminal defense attorney, particularly when you have an interplay between a criminal investigation and a civil investigation, which is happening more and more frequently now, be it in the context of SEC investigations coming out of the financial crisis, healthcare fraud, Medicaid, Medicare fraud, anti-kickbacks, things like that. We see it increasing in those areas certainly over the past couple of years, but it also touches virtually every industry that we work with, be it real estate, banking, agriculture, insurance, you name it. Chances are someone in this room has dealt with some sort of parallel proceeding. I want to talk about one specific example that relates to the point I just made about people not viewing themselves as criminal. I was recently working on a case for a hospital where we were representing the hospital in connection with civil litigation involving allegations that a certain doctor who was credentialed and employed by the hospital was performing literally hundreds of unnecessary procedures on patients in order to increase his billings, and that the hospital and the doctor made tens of millions of dollars in the process. I happened to be down at the hospital the day that the CEO got on his desk a request from the Attorney General, not a request, a demand from the Attorney General's office in the state saying, turn over every document that you have related to this topic. He called me up to the office and said, I just received this, here's what we're going to do with it. We're going to give them everything we've got. That's the end of the story. Make it happen, and make it happen yesterday. This was a situation where he didn't view himself or his company as doing anything criminal, and he wanted to make it go away, and he wanted to make it go away yesterday. Now, the parallel part of these proceedings arises because we were dealing with incredibly aggressive plaintiff's attorneys on the other side. And we were also dealing with very sensitive peer review materials in that case that we didn't want to turn over in the civil litigation.
You're also dealing with a harsh moderator. You have a minute left.
Then I'll wrap up and be quick. The bottom line is you had to be very careful in terms of what we turned over to the government. And the key concern when you're talking about what am I going to disclose to the government in an investigation where there is a civil parallel proceeding is that you don't want to wind up turning over materials to the government that could later be turned over to the plaintiffs in your civil lawsuit and used against you. It's an issue that arises frequently, and it's very important because most courts don't like the doctrine of selective waiver. That is, if you turn over privileged or protected materials to the government, some court down the road in a civil proceeding looking at that is going to say, sorry, you turned it over once, that's all you get. End of story. So that's one of the key considerations that you need to consider when you're dealing with parallel proceedings. There's a lot more, but I'll defer to Jack and stop talking now.
All right, one particular area, both as a business concern and as an enforcement priority, has been the Foreign Corrupt Practices Act, which is a very powerful statute. Now, I ain't foreign and I ain't corrupt, so I'm not going to speak to it. But it still comes up, especially for many people in this room and for our friends who aren't here. And Jackie is going to spend a few minutes talking about the FCPA and how both one's experience as a white-collar lawyer gives us some insights into how civil lawyers and business people can helpfully think about it. Jackie?
Thank you. Well, the FCPA really is it seems to be the statute du jour. Back in November of 2010, Lanny Brewer, who was the then Assistant Attorney General, spoke at a conference and he said, we are making FCPA our priority, and we're going to fund and staff the unit, and we are going to go after the violators, and we're going to go after them aggressively. And they made good on their promise. They staffed the FCPA unit with many additional lawyers, and they started aggressively prosecuting the cases. And now, just so you know, the FCPA prohibits providing or offering anything of value to a foreign official with the intent of obtaining or retaining business in that foreign country. It's the enforcement, but basically there's both the DOJ and the SEC that have enforcement authority. And with respect to the SEC, there's accounting provisions, maintaining of books and records. So it's rather complex, but it's something that really any business that does any business in a foreign country needs to be aware of. There are some DOJ papers that can be of assistance. One of them is the Principles of the Prosecution of Business Organizations. Really, every business organization should pull that up. I'm happy to provide the site to you. But they discuss what the DOJ looks at in determining when to target a business organization, and once they've targeted a business organization, what are some of the factors that they consider. Obviously, compliance policies are high up on the list because they want to see that corporations, particularly in the FCPA context, have compliance policies in place and have them with teeth. So they want to see training. They want to see materials that show continuing training. They want to see evidence that shows that the board is, and senior management is on top of this and really cares about it. They want to see that there are appropriate disciplinary proceedings, that there is a vehicle for confidential reporting, self-policing, self-remedying. In the event of an infraction occurring, that there is an internal investigations that occur, and that the results of the investigation, if appropriate, are reported. So they take a look at all of that, because obviously if there is a compliance policy in place, if companies have FCPA language in their contracts with their foreign partners, with their employees, with consultants, with attorneys in foreign countries, they take whatever steps and measures they can to prevent violations from occurring, but a violation occurs notwithstanding all of those efforts. Those efforts will be taken into consideration by the DOJ and the SEC, or at least they claim that they'll be taken into consideration. There's also another paper called it's the DOJ FCPA policy that has recently come out about a year ago or so, and that talks a lot about what is a foreign official, jurisdictional, which, by the way, jurisdiction now has been an evolving issue in FCPA cases, and it appears as though jurisdiction is expanding. What is anything of value? What are the intent requirements? So there's a plethora of information if you just go to the DOJ website and look up the FCPA manual. Again, if anybody wants a link to it, I'm happy to provide it. But it's something that everybody needs to keep in mind, because you think that your company is not out there bribing foreign officials, but it could happen in a way that may not even register to your awareness. So you have to have those policies in place and make sure that you stay on top of them and have continued training and modification of those policies if necessary to ensure that you don't run afoul of the FCPA. Like I mentioned, the DOJ in the past few years has continued. They've collected billions in fines and penalties since 2010, 2011. There was a dip in 2012, but one of the things that have occurred in 2013 that's been of relevance is the DOJ's been going after individuals as well. So they're not just fining the companies and entering into deferred prosecution agreements, but they're going back and they're reviewing those deferred prosecution agreements, and they're reviewing those settlement agreements, and they're saying, are there individuals here that we should be prosecuting? And they're prosecuting them. And 2013 has shown that they're actively doing that now. So, so that just gives everybody much more reason to have heightened awareness.
All right, great. Thank you very much. We've got to move on, unfortunately. I'm Jack Sharman. I'm a partner at Lightfoot Franklin White. I do a lot of white-collar criminal defense and government investigations. And I talk to lots of friends and clients about that. One question that comes up frequently is, what do I do when the government shows up at my office or at my factory?
Let's talk for a second about search warrants. Search warrants are different than subpoenas or informal requests for information. With a search warrant, first of all, they're coming in. This is not a situation where we're going to get a different or deferred appointment. Secondly, call the lawyers, the law department, outside counsel, or both, because the company's lawyers are way behind wherever the government investigation is. Thirdly, stay out of their way. We don't want to add an obstruction of justice charge to whatever other ills are pending for the company. On the other hand, we need to know what's happening. So watch them and follow them. Try to get identification from the agents, especially from the lead agent, and from the line prosecutor if he or she is there. In addition, we want to get a message to employees, which is they have the day off. They should be told that they may, if they wish, speak to agents. On the other hand, they don't have any obligation to do so. Or if they wish to speak with an agent but have a company lawyer present, they certainly have that right. In addition, government agents are not often terribly sensitive about privileged material, and especially attorney-client material. So if during the course of the execution of the search warrant, you see the agents go into areas where you would expect there to be privileged material, for example, the office of an internal lawyer, ask the agents to take the seized material, segregate it, seal it such that a judge eventually may make a decision. The important thing is to not make a bad situation worse.
I just love me some me. I just love to watch that. We got time. I might play it again. Search warrants, a couple of quick things. One is the government often uses search warrants to establish intent. This is the scene of a business search of a specialty pharmacy office. You can tell it's a search because the agents, who are sometimes lettered, sometimes unlettered, actually put letters on the walls to help them remember where they've been. That's the W up there. The desk of the CEO had, as such desks do, many papers on it. At trial, the agents originally testified that they found these documents like this, but in actuality, it transpired through the photographs that they were neatly stacked, and the agents spread them across the desk because they wanted to highlight the document that is at the far left, which was a printout from the internet about what is the anti-kickback rule. This being an anti-kickback prosecution, the government thought that was very helpful for arguing with intent, and the AUSA argued in opening to the jury that they would in fact see proof of intent on the owner's desk simply by virtue of the research document on his desk. So that's one thing, that don't just think that a search being executed is only about somebody else. It's often about you and about what's in your mind. Similarly, as I just said succinctly and persuasively, the agents are not generally sensitive to attorney-client privilege. This is particularly true with regard to seizure of electronic materials, which are by nature difficult to segregate. The practice point there is to raise that point immediately so as to not waive the privilege. And then finally, and perhaps the most useful in my experience for the government, useful, is witness interviews, which is why we do encourage everybody to take the rest of the day off. That scenario that I opened with about going to visit with employees after a search warrant and the employee coming in and saying, "I'm on the side of the FBI, whose side are you on?" actually happened to me. And I said, "Well, sir, let's take a step back and renew our relationship again." But the interview point is particularly sharp in light of a fairly little noticed Supreme Court case this past term called Salinas, S-A-L-I-N-A-S, and its description's in your material. It's actually a Texas state murder prosecution, but the upshot of it is that the Supreme Court held, essentially, that in order to invoke one's Fifth Amendment rights, one must be specific about it. The court didn't say what magic words were or were not required. The problem for business people is that, as we started out discussing, nobody thinks of themselves as a criminal. All of our internal clients and employees and officers are loath to invoke their Fifth Amendment rights. There's no limit in Salinas to criminal cases. And so what it counsels is ever greater vigilance for our employees, our colleagues, and our clients, that it is not necessarily un-American to decline to speak with an agent or to ask to do so, but only in the presence of his or her personal counsel or the company counsel. All right, we're out of time. Thank you very much.